Good evening, everyone, and welcome. My name is Kyla Hannington, and I am the Public Outreach and Engagement Division Manager with the Prince George's County Office of Human Rights, the county's civil and human rights education and enforcement agency. Since 2020, the Office of Human Rights has been partnering with the Prince George's County Memorial Library System to bring you virtual events, including the series Voting, Democracy in Action. In this series, we look at democracy and civic engagement because we know that true social justice depends on true democracy. Tonight, as part of that series, we look at the recent Supreme Court decisions and democracy. If we think back to some of those decisions, well, what were the big decisions? What do they mean for us? And what do they mean for our democracy? The three panelists, who I'll introduce in just a moment, will look at these issues in a roundtable discussion. For those watching, please bring forward any questions you may have in the chat as we go along, and I will share them with the panelists as time allows. And we are grateful that you are all here with us tonight. Our three panelists are legal leaders from our area, and we are honored to have them as our guests for this evening. And I am going to take a little bit of time right now to read their bios for you before we get started, because I want you all to know who we have with us. They are worth taking the time to hear about. Renée Battle-Brooks has spent most of her legal career as a litigator, first as an assistant public defender in Maryland for 8 years, and as an assistant state's attorney for Prince George's County, Maryland. She spent almost 19 years as a prosecutor, specializing for 12 of those years in the prosecution of child abuse, sexual assault, and human trafficking. Human trafficking crimes. In December of 2018, Ms. Battle-Brooks was appointed as the executive director of the Prince George's County Office of Human Rights by County Executive Angela Alsobrooks. The Office of Human Rights, as I said, is the county's civil and human rights education and enforcement agency. And at our office, Ms. Battle-Brooks lends her services to community issues and groups. She's served on the Maryland Coalition Against Sexual Assault Board as president and board member. And in her spare time, she plays violin with various groups and ensembles. So, Renée, it's great to have you tonight. Gabriel Christian is a highly skilled veteran trial lawyer attorney and a Georgetown Law School graduate. His areas of legal practice include personal injury litigation, criminal defense, church and religious organizations, international law, commercial law, business organizations, family law, personal injury, environmental law, and sustainable energy law. He is deeply involved in community service, offering his time to the citizens of Maryland, business organizations, religious organizations, the school system, and the Caribbean community. He is an accomplished writer with public works including In Search of Eden, Dominica, The Travails of the Caribbean Mini-State, Rain on a Tin Roof, Death by Fire, the explosive story of the 1962 Carnival tragedy, For King and Country, the service and sacrifice of Dominican soldier, For King and Country, the service and sacrifice of the West Indian military, and Mamo, the life and time of Dame Mary Eugenia Charles. He is a member of the J. Franklin Bourne Bar Association, the Prince George's County Bar Association, Maryland Bar Association, National Bar Association, Goldstein Inn of Court, Alan J. Goldstein Inns of Court American Bar Association, Dominica Academy of Arts and Sciences, Tuskegee Airmen Association East Coast Chapter, and is a board member of the Caribbean Research and Policy Center. He was appointed a judicial commissioner to the Maryland Court of Appeals in 2007 and appointed a commissioner on the Governor's Commission of Caribbean Affairs in 2012 by Maryland Governor Martin O'Malley. Gabriel, it's nice to have you back with us. Thank you so much for joining us tonight.
The only thing I'll say is next time you cut that by 2/3.
Okay.
Thank you. Good to see you, Kyla. Good to see you, Renée. My good friend, Professor Higginbotham. Good to see you, sir.
And Professor Higginbotham is a Lawrence M. Katz Professor of Law and former interim dean at the University of Baltimore School of Law. He is the author of Race Law, published by Carolina Academic Press in 2001. And now in its 5th edition, the book is widely used in colleges and law schools throughout the United States. His latest book, Ghosts of Jim Crow, was published by NYU Press in 2013. Higginbotham has published numerous articles in journals, including the Yale Law and Policy Review, the Harvard Black Letter Law Journal, and the New York University Law Review. He has published numerous editorials in newspapers, including the New York Times, the Boston Globe, and the Baltimore Sun. Before joining the University of Baltimore in 1988, Higginbotham was a law clerk to United States Court of Appeals Judge Cecil Poole, an associate with Davis Polk, and a lecturer at the University of Pennsylvania. Higginbotham received a Bachelor of Arts degree from Brown University in 1979, a Juris Doctor degree from Yale, a Master of Law degree with honors from Cambridge University, where he was a Rotary Scholar. So first of all, welcome all of you. What a fantastic panel we have. We're so happy to have you with us.
Thank you, Kyla. At full disclosure, I'm a University of Baltimore graduate, and Professor Higginbotham was one of my professors. So just in full disclosure, Georgetown has nothing on us, Gabriel Christian.
I agree.
So yeah, we're thrilled that both of you are here to help with this panel. And for those who tune in regularly, you know that we always like to lay foundation because civil and human rights are vital to democratic processes, but also to everything that we do in our lives. And so I know that Gabriel and I have been on prior panels, and I know that Gabriel likes to sort of set the foundation from the Civil War. So I would ask maybe that you start with that, and then Professor Higginbotham, if you want to sort of give contextual information about the courts and why this is all important.
Thank you, Renee, for having us this evening. Good to see you again. Good to see you, Kyla. And so good to see Professor Higginbotham. We served on the Judicial Commission of the Maryland Court of Appeals, or the Maryland Appellate Courts, for about 7 years. That institution in and of itself was a product of a society evolving, in the words of Abraham Lincoln, towards a better union, a more perfect union. Because what it really did was allowed the citizenry to provide sort of a vetting mechanism to look at not only the academic qualifications of persons who applied, but what was the quality of their civic leadership? What was their involvement in society? What was the sort of what legal philosophies did they embrace, if they had any? And to almost interrogate those persons. And at the end of that process, and Professor Higginbotham was a fantastic personality, because he brought to the table all of the academic seasoning that he had acquired over the years. But he also brought into the room the history of those of African descent, because the African American in U.S. history has been the sort of canary in the coal mine. You know, in the old days before the growth of technology that allowed you to assess the amount of carbon dioxide in a mine, you would put a little canary in a little cage, and if it died, it meant you had to get the heck out of that mine, because it was becoming too saturated with CO2. Because all of the struggles that African Americans have engaged before the Civil War, during the Civil War, after the Civil War, to this date, has benefited poor white folk, women, Hispanics, Jews. You know, it's been a sort of dispensation that was not ethnocentric. It was a dispensation that focused on, let us try to adhere to the philosophy enshrined in the Declaration of Independence. We know it well. We've heard it said. All men are what? It didn't say women, but in those days it meant women are created equal. But we know that that was not the case. That was not the case. And so we had to get to a place where we confronted in the United States, leading up to 1861, the Dred Scott decision. The Dred Scott decision, basically, as Professor Higginbotham, who is much more erudite and eloquent constitutional scholar than I am, took the position that Congress had exceeded its authority with the Missouri Compromise, where, you know, the whole idea of whether the state was going to be a slave state or free state, that really set the stage. And when Congress acted in the way that it did, it inflamed what was called in those days sectional tensions. And what was the main fissure in the society? It was the issue of slavery, or what was called in the parlance of that time, the slave power. And so we had Dred Scott. And then we had, of course, a certain individual who is not much talked about today. But if we had to be honest, and committed citizens of the United States. We must not know some of the history, we must know all of the history. It means we have to understand that the U.S. Has a national anthem. Oh, say, can you see, out of Baltimore Harbor and Francis Scott Key, but the battle hymn of the Republic, I posit this evening, really evokes the true nature of the American spirit in its call for freedom. Human freedom is evocative of the battle hymn of the Republic. And interestingly enough, for those of you who are listening, go to YouTube and put into YouTube John Brown's song, and then put into YouTube the battle hymn of the Republic, and you will see, or you will hear, what I'm going to say tonight. The battle hymn of the Republic, the revered battle hymn of the U.S. Republic, is John Brown's song. Now, I don't carry a tune too well, but it goes something like this. John Brown's body lies a-moldering in the grave. Oh, John Brown's body lies a-moldering in the grave. John Brown's body lies a-moldering in the grave, but his soul keeps marching on. So as a 7-year-old Cub Scout on the island of Dominica in the 1960s, we sang that song on the way to camp. But I didn't know who John Brown was. Mm-hmm. Now, I'll say that it's a place that I make a pilgrimage to. That is Harper's Ferry, where he took his stand. And because John Brown took his stand to set men free and women, because as you know, the abolitionist movement in the United States was a movement that was made up of African Americans, male and female, and very prominent white females. Very prominent white females who later got, of course, I think, Professor, it'll be 1921, you got suffrage after the suffragette movement for women. It took that long. But the Civil War came because John Brown took a stand to free the slaves. And Abraham Lincoln came into office, and we know what happened. I will conclude by saying that I have here an article. It's a very important article. It's titled, Yes, John Wilkes Booth did speak these notorious words at Lincoln's last speech. Lincoln's last speech on the portico of the White House is when he basically said for the first time that now that the war is won, that we should consider the vote for those who have faithfully served the Union, or at least the intelligent amount of them. He was talking about the tens of thousands of African-American soldiers who had served in U.S. colored troops. And the record is that John Wilkes Booth, who had been plotting the assassination of our late great president, heard him speak that night. And he said, N-word suffrage. I will not repeat, but you know what I mean. N-word suffrage. That's the last speech he shall give. I shall put him through. And he did. So the history of our country, the history of the civil rights we enjoy, the history of the Supreme Court, is inextricably tied to the quality of the democracy or lack thereof. And we had a very learned judge, I'll conclude, who is no longer sitting on the bench. The last time we were here, Judge Wallace, who said, it can be argued persuasively that it's only in recent times that the United States has become a democracy. Was the United States a democracy prior to the abolition of slavery or the 13th or 14th Amendment? Anybody who is of reasonable intelligence today would say no. Was the United States a democracy before women were afforded the right to vote in the 1920s? Almost half the population? Certainly no. Was the United States a democracy when African Americans were denied their rights routinely to vote in the South and many other parts until the Voting Rights Act came into being? Again, the question, I believe, can only be answered in the negative, that it was not. And so what we're saying this evening is that the Supreme Court that we have mirrors the society that we have, where we fail to vote in a way that is supportive of the principles of the expansion of democracy and equality of opportunity society, a society that does not exalt class prejudice or racial prejudice or ethnocentricity, one that affords the greatest good to the greatest number. If we can inculcating our citizens the importance of the voting, rights that they have, that those rights having been purchased at great cost in sweat, toil, and blood and tears. If we can persuade our young ones and old ones to vote, we would see political leadership, hopefully, that is more inclusive, that is more respectful of the ethos of the American Republic as exemplified in that great excerpt from the Declaration of Independence. And we can see a Supreme Court that's more reflective of that desire for the onward march of our civilization with greater freedoms for all people, not less.
Thank you. Thank you. That was a great overview, or a historical overview. I'm wondering, and maybe Professor Higginbotham, if you want to tackle, and maybe just give us a little bit of, reflecting on what Mr. Christian had to say, and how where are we now? Like, what's happened recently that has draws these lines through from what Mr. Christian has said.
Okay, happy to do so, and thanks for the invitation. I'm delighted to participate. So proud of my former student, Renée Battle-Brooks there. When the professor sees his former student doing so much, that makes teaching so wonderful. Delighted to see my friend Gabriel Christian. Gabriel makes very powerful points about our history. Who we are today is not who we were. And so when you start thinking about some of Gabriel's points, it becomes very important to know our history. Because if you don't know where you've come from, sometimes it's hard to figure out where you need to go. Now, we're going to talk about cases, Supreme Court cases, and democracy. It's a very broad topic, but it's a very critical topic because, as Gabriel talked about, the Declaration of Independence and the most powerful words in that declaration of self-evident truths. That's what we've struggled with in this country, to try and live up to those self-evident truths that all are created equal. And we've struggled with that for several hundred years, and we're still struggling with it. And that's what we're dealing with today. But what's important is to understand we've got some wonderful concepts. The founders got a number of things wrong, including the slavery question, which the Supreme Court in 1857 in Dred Scott got wrong, but which we finally got right with the 13th Amendment in 1865. But when you start thinking about some of the concepts they got right, separation of powers, a very important concept, that you distribute power from three branches of the federal government. Congress passes the laws, the president enforces the laws, and the judiciary interprets the laws. Separation of powers. And each branch has a distinct role, but it also has a check on the other branches. Very important concept, one that I've been delighted to see particularly over the last 5 or 6 years with the administration of President Trump, because when you have a president that's exercising excessive authority, the legislature and the judicial branch can put a check on that. And sometimes they do a more effective job than other times, but it's nice to have that concept. And so when we start thinking about some of these cases dealing with democracy, certainly the court plays such a significant role in our society today, and it has in the past. Our society today plays a very important role in terms of checks on the legislative branch and the executive branch, because it is the final interpreter of the law. The Supreme Court, and Renée Battle-Brooks will know this from her Con Law 1 days, Marbury versus Madison 1803 case, the Supreme Court said, we're the final arbiter. We're the final interpreter of the Constitution. And so they can strike down legislation. They can strike down things that the president does in terms of policy or practices of enforcement, because they are the final arbiter. That's why the cases we're going to talk about today are so important, because the court, as it did in Dred Scott, as it did in Plessy versus Ferguson, the court is the final arbiter of constitutional disputes. It's the last word. And so today, in terms of democracy and Supreme Court decisions, there's a whole lot of them. Biden versus Nebraska, the student loan forgiveness case. Moore versus Harper, the independent state legislature theory case. And Adonis versus the United States, which is the free speech and criticizing public officials on the internet case. These are all cases we could talk about. But for me, most important cases dealing with democracy, dealing with our subject matter, is the Students for Fair Admissions versus Harvard, the affirmative action case, and Allen versus Milliken, the voting rights case. I think these are two of the most important cases on democracy. And I will say this, I'm happy to talk about either of those cases or both of them now or whenever the moderator would like me to talk.
Well, I think if this is okay with Renee and Gabriel, I think it would be wonderful if you could provide even just an overview of both of those cases, so people who are listening who maybe are not as familiar. And again, please, Renee and Gabriel, jump in, but just to provide that background of what those cases are would be great.
Maybe we could start with the Harvard case and then move to the other.
Happy to do so. Affirmative action, one of the most controversial and divisive issues over the last 50 years in my con law class. It always creates huge discussion. And usually the class reflects not only the court's division, most of these cases have been 5-4, and the society's division. It's a very divided society on affirmative action. It has been for a long time, and the court has been divided. And that's probably because when you have a society like we have, with a long history, as Gabriel has mentioned, of race discrimination and racial segregation, and then that society says, that wasn't right, that was wrong, so we're going to now require equality. We're going to put it in the Constitution. When you have that kind of a history and then that kind of a change, defining the meaning of equality under those circumstances is not going to be easy. It's going to be, it's going to create some controversy, and it has from the beginning. 1883, and I know Gabriel particularly enjoyed this, and I'm supposed to be the scholar on the panel. People keep referring to me, the professor, but I listened to the biography on Gabriel. He's got more books than I've got, and he's a practicing lawyer, with all these books. So we got at least two scholars on the panel. But in any event, what you have is you've had a divisiveness in affirmative action since 1883. And I know some of you are saying, well, come on, what are you talking about? Affirmative action is just created in the 60s. But if you look at the civil rights cases of 1883, where the court was asked to determine the constitutionality of one of the first civil rights acts, the Civil Rights Act of 1875, that said no discrimination in public accommodations, trains, theaters, employment, that kind of thing. No discrimination, no racial discrimination. The court ruled 7-1 that the 1875 Act was unconstitutional. And in the majority opinion, Justice Bradley said, at some point, at some stage in their elevation, Blacks must take the rank of mere citizens and cease to be the special favorite of the laws. Now, when I read that to my class, my common law class, a lot of students start to giggle, embarrassed. They're embarrassed, but they giggle because of how ridiculous that statement is. Because Justice Bradley, in striking down the legislation, he says, look, at some point, blacks have to stop being the special favorite of the laws. What is he talking about? Blacks are the special favorite of the laws? What he's talking about is the 13th, 14th, and 15th Amendments to the Constitution, which simply say no slavery, there should be equality of treatment of everyone, irrespective of race, and there shall be no discrimination in voting. So he looks at these amendments and he says, those amendments are treating blacks in a special way. They're giving blacks preferences that other people aren't getting. Now, we all know that those amendments apply to everybody. Nobody can be enslaved. Nobody can be discriminated on the basis of race in their exercise of the vote. That's what the Constitution says. But Justice Bradley perceived that as affirmative action. So it's been with us this debate has been with us for a long time. The Harvard case is the latest manifestation of that debate. And what the case said, and you had students that were mostly white and Asian students bringing a case challenging Harvard's practice, which was complicated in terms of admissions. But basically what it says is that if you have some underrepresented groups, once we determine that everybody is academically qualified, we may give a preference to individual applicants from these underrepresented groups if it's a close call. That's pretty much what the Harvard admissions policy was. Supreme Court says that's unconstitutional. That's a violation of the Equal Protection Clause of the Constitution, which says no state may deny the equal protection of the laws. So 6-3 decision. And it's very important to look at the majority reasoning and look at the dissent. As a professor, my job is to critique. And I always tell my mother, because she gets worried when I go on stuff like this. She says, you're going to say something controversial, especially when I'm on CNN and got millions of people watching. And she says, you're going to say something controversial, you're going to get fired, and then you're going to have to move home. And my mother's 98. And she said, look, that ain't happening.
God bless her. She's 98. God bless her.
She's 98. Going strong too. So I tell her, Mom, I got something wonderful, which is called academic tenure. So I can say what's in my heart. I can't be fired. So let me tell you what I think about this Harvard case, which is not very much. 3 problems with the majority's decision. 1, politics. This decision is more political than based on some sort of jurisprudential reasoning, some sort of precedential decision-making. Why is it about politics? Because if you look, it goes back to 1980. President Reagan was elected on a landslide, comes in 1980, and part of the Reagan Revolution is a litmus test for the appointment of judges. Gabriel talked about how we sat on the judicial appointments in Maryland. We had no litmus test. Reagan had a litmus test. He said, nobody who is pro-affirmative action or nobody who is pro-abortion can be appointed to the judiciary. So that started this approach of making affirmative action, as well as abortion, political. And if you look at what happened since 1980, all you have to do is look at the Supreme Court, the confirmation processes, the lies that many of these individuals told in their confirmation decisions. We can talk about, Justice Alito. We can talk about Justice Kavanaugh. We can talk about Justice Amy Coney Barrett and what they said about affirmative action and abortion, and then look at what they just did, which is like night and day. And so this has been very political. The Republican Party has carried on that Reagan revolutionary approach, And the 6-3 decision in the Harvard case, as well as in the abortion case, the Mississippi abortion case, represents that political evolution. If you look at the jurisprudence in the case, it's extremely problematic in terms of one, the majority doesn't consider the diversity rationale. Actually, it doesn't deal with the critical mass rationale that previous courts upholding affirmative action have talked about. They said, look, you got to have a critical mass. If you have a critical mass, that changes the dynamics of the class and of the classroom in higher education. That's why it's of value. The majority doesn't deal with that aspect of critical mass. They say it's because Harvard didn't argue it. But when you're a Supreme Court justice making decisions, you don't have to worry about what was argued. You just have to worry about what is constitutional. Second, the standard that's applied to affirmative action going back to the Adirondack decision in 1996, the standard is strict scrutiny. And for the lawyers out there, you know, I'm talking about it's a high level that the government must meet in terms of affirmative action programs. You have to have a compelling government interest. You just can't have a good reason. You have to have a great reason. So the court in 1996 in the Adirondack case said strict scrutiny. The government has to have a compelling reason in order to have affirmative action. Now, four dissenters back then said that makes no sense, including Thurgood Marshall. Said, look, that makes no sense. All they should have to have is a good reason. They shouldn't have to have a compelling reason. But 5 justices, 5-4 again, said no, strict scrutiny, compelling government interest. But what the majority doesn't then deal with in the Harvard case is why isn't remedying the effects of past discrimination or the present impact of past discrimination, why isn't that compelling? They don't talk about that. What happened to that? That was in the Grutter case, that was considered compelling. All of a sudden now Justice O'Connor's not on the court. All of a sudden you got new justices and they say, hey, we don't know anything about that. They just talk about the diversity rationale not being compelling. So there's some real problems with this decision. And then the final thing, and this is what Gabriel was referencing earlier, is history. If you look at the decision, you've got 6 in the majority, 3 in the dissent, and they both talk about our history. But the majority, and I got to say it as a professor, the majority gets a D- in history. They say, well, we had slavery and we had segregation, and the Supreme Court, like society in general, got it wrong. And then they say in 1896, and then they go on to say, okay, Harvard, you can't do this today. The dissenters, they say, oh, wait a minute. That happened in 1896. You're right. But then what happened between 1896 and 2023? The majority doesn't talk about that. And the dissenters say, that's relevant. That's the compelling government interest as to why we need affirmative action. So, you know, that's my super nutshell on the Harvard case. Allen, I can talk about Allen versus Milligan real quickly, Renee.
I just wanted to jump in really quickly because as you were talking, the thing that struck me, I mean, all of that did, but this whole, what I believe to be subterfuge about, the 25 years that Grutter talks about, and we're almost at the end. And I'm thinking 25 years, we were in slavery for 403 years. And 25 years, right? And as you are unpacking the legislative history, there's never been a time where there's been consistency of enforcing the laws, enforcing the Constitution, the amendments. So it's anyway.
There's tremendous hypocrisy on this from the right, tremendous hypocrisy from conservatives on this. And I would just say, I worked on the South African Constitution. I was involved in that democratizing South Africa process. And one of the most fascinating things was to look at what Black South Africans did in their constitution, because they looked at the United States and they said, hey, we see what the court has done on affirmative action, how it's kept narrowing and narrowing and narrowing what you can do. So you know what they did? They put in their constitution, they said, look, we're going to have equality, just like we put in our constitution here. But they also did a caveat. They said there can affirmative action, reasonable and justifiable affirmative action, cannot be prohibited as illegal discrimination, because they saw what had been done here. Yeah. They saw how the court had eroded the affirmative action concept. And so they said, we're not going to have that in South Africa. So it's fascinating to look at. One other thing, white South Africa.
I think you need to repeat that for the listening audience.
Yeah.
If you don't mind.
So the Black South Africans said, we're not going to make the mistake that was made in the United States, where the court has been able to erode irresponsibly the concept of affirmative action and how it should be legal. And so what they did is they put in their constitution in 1994 a provision, not only an equal protection clause as we have, but also a provision that protected affirmative action against any South African court attempting to unduly restrict the government's use of affirmative action to correct for past discrimination. It's a big deal. It's a big deal. One other indictment.
Can we credit you with that?
You can credit me with that. You can credit me with that. It's a big deal. It's a big
That's
deal.
A huge deal.
One other indictment of current America. Not one white South African in these negotiations, not one of them stood up and said, all we need for protecting minorities in a multiracial democracy, all we need is what you do in the United States. In fact, most of whites stood up and said, what you have in the United States is inadequate protection for minorities. We can't accept that here because that's not adequate protection. And what they were talking about is an equal protection clause and then a legislature that passes anti-discrimination laws. Yeah. They said that's not adequate protection. Yeah. They need more guarantees in the Constitution. So fascinating to see that dynamic in a multiracial democracy where blacks are the majority and whites are the minority.
No, it's fascinating. I just want to jump in for a second because I'm sure our audience knows, but I think it bears discussion, or at least a definition. You know, the word affirmative action has such a negative connotation, right? That's how it's been spun. But could you, Gabriel, either of you, really lay it out in simplistic terms exactly what it is? And it is not something that somebody is given.
Well, first of all, it's not, and Professor Higginbotham is much more. First of all, I want to just compliment you because in college at the University of DC, I was the chairman of the DC Student Coalition Against Racism and Apartheid. And so we marched and did all kinds of things. And at Georgetown, we had the divestment program. And so we sit on a panel. Look at how far we've come with someone of your stature who made a material contribution to the advancement of a major democratic process, the most important one of our lifetime.
It is.
Because literally the South African folks were enslaved.
Yeah.
Bottom line, they had no rights.
Yeah.
Worthy of being respected. And you were part and parcel, and if not the tip of the spear, in ensuring that particular constitutional clause that would preclude a future government from sort of taking apart the affirmative action structure to balance and or mitigate and or overcome historic prejudices that found their way into laws governing education, governing business ownership, ownership of land and the like. And that is to now. Thank you, President.
Yes.
Well, I appreciate that. And one of the most moving experiences I ever had was in 1994, being in South Africa for the first democratic election and seeing 88% of the population in South Africa voting. 3 days. Some people stood in lines, man, for 2.5 days. 88%. And then to look at American democracy and know that, less than 50%. And in fact, last time I think it was 45% voted.
Yeah.
So
shameful.
So I really hope that this represents a clarion call when you make a note of that percentage, the 80th percentile. To all of those folks who will listen to this program, please understand what it is we have cannot be treated lightly or taken lightly. It was purchased at great cost.
Yes, it was.
Blood, sweat and tears and toil. And so, folks, the bottom line is voting is intrinsic to the perfection of our democratic processes. And democracy is not a spectator sport. It is a very serious enterprise that must be seized of with the utmost gravitas, if I can use that term.
Yeah.
And to say what, I guess, to respond to Ms. Battle-Brooks' comment, affirmative action to me represents a public policy instrumentality to redress historic wrongs. It is not what the folks who are on the extreme side of things, I don't want to even go left or right, just folks who are extremists, who are seized not of fairness but of prejudice, try to pretend is some favoritism to people who happen to be Black. It is not. When Professor Higginbotham or myself or any one of us had to go to law school, we first had to do the LSAT exam and then get in. And before that, we all had to get good grades and graduate college. And then after that, while in law school at Baltimore or Harvard or Yale or Georgetown, we had to take exams with our peers. You didn't have a white exam and a Black exam or an Asian exam. And we had to pass those exams before we took the bar at the end of our graduation from law school with the JD. So it is preposterous. It's the height of hypocrisy. It's utter foolishness for those persons who are seized of prejudice to keep perpetrating the lie, the mischief really, that it is that affirmative action is some sort of favoritism. All it is doing is saying for hundreds of years in this country, if you were Black, stay back. If you're white, you're all right. If you're brown, you may stick around. But the reality was you were excluded. And that historic injustice has caused within the body politic the cancer of discrimination to metastasize. That's what it is.
Yeah.
And to result in lack of ownership of business, lack of ownership of land, lack of opportunity to really have a profession in physics or chemistry or mathematics, lack of access to the financial resources to elevate your condition. Because all of those things are intrinsically related to your educational opportunity. If you're a physicist, for instance, if you're Robert Oppenheimer, that nobody can say that you're a Jew coming from a mile away, and you get into Harvard or wherever he went to school and become a great physicist, the power of your knowledge in that moment, even after they found out that you're Jewish, is of such power that you have access. And I don't know whether you know the story. So when Oppenheimer came out, I went to see it because he is a person who I have a lot of respect for. And I discovered that the first time, Professor Higginbotham, this was amazing. I don't have his name, but I'll try to get it before the end of the program, that a group of white scientists were under the direction of a black scientist was doing the Manhattan Project. Mm-hmm. And I wonder why. Mm-hmm. Maybe it had to do with the humanitarian impulse of one Robert Oppenheimer. Mm-hmm. As you all know, after the war, suffered because of his humanitarian instincts. He was blacklisted. Mm-hmm. And so the Manhattan Project, the gentleman was a Harvard grad in chemistry, a PhD from Harvard in chemistry, who went to Harvard in the 1920s and was not allowed to room in the dormitory. He had to find space elsewhere. But he struggled through and got a PhD in chemistry. Online, you can actually find some of his work. It's been declassified, his notes and everything else. So here was a product of the Civil War and the 13th and the 14th and the 15th Amendments of the U.S. Constitution. But he was just one in a million. And what affirmative action has sought to do in the United States is not to give black folk a pass, but it has sought to open the doors to equality of opportunity. And because of that, some folk, as you mentioned, Reagan, have made it such that there's now a litmus test that if you're going to go up on the Supreme Court, you have to telegraph where you're coming from, that you're anti-affirmative action. You've got to telegraph where you're coming from if you're anti-abortion. And I believe that has undermined our democracy because it does no good. Okay, for me to be going to court before Judge Higginbotham, for me to know that even before I open my mouth, and he listens to my reasoned arguments, that I'm dead on arrival because he has made it known through his lectures and through his different engagements that he has a bias against folks who are black, although it may be clothed in more delicate language.
Yeah, I think, and because we do need to move on to the other case, but I think for me and to help folks, affirmative action really is just as it says, because human nature and our history has shown us that we are disinclined to be inclusive when we're not forced, or we're not inclined to even think about inclusiveness. And I'm not placing a judgment on that. I'm saying that is human nature. You are friends with folks that believe like you, that live where you live, et cetera, right? So it is like just saying that you have to affirmatively think about being inclusive. That's what the law says. You must make that part of your decision making. But go ahead, Professor.
Well, see, I think that's such an important point you make, because our laws on anti-discrimination are so inadequate. We may not need much affirmative action if we had some decent laws on anti-discrimination. What I'm talking about, one of the worst Supreme Court decisions ever is the McCleskey versus Kemp case from 1986. It's a death penalty case. Warren McCleskey was black. He was convicted of first-degree murder in Georgia, sentenced to death. On appeal, McCleskey argues that I'm 4 times as likely to get the death penalty because I'm black and my victim was white. 5-4 decision. 5 justices in the majority say, McCleskey, we're not convinced that your argument constitutes a violation of the Equal Protection Clause. All 9 justices say, we have no question with the study. There's a very sophisticated study that the Legal Defense Fund commissioned. And you had a law professor that isolated 254 variables as to why McCleskey's getting the death penalty. And it came down to the only real issue, the only real factor that's critical is race. His race and the race of the victim, and it's a 4-to-1 differential. All 9 justices say, great study. We're convinced. We have no question at all about this study. But what's the problem? Equal Protection Clause requires intentional race discrimination. And this is not enough to constitute intentional race discrimination. What did 4 dissenters say, including Justice Marshall? When we see a 4-to-1 study like this that we have no issues with in terms of its credibility, and 2, when we know the history of Georgia capital sentencing, which is filled with racial discrimination laws, when we see those 2 factors, the hair on the back of our necks starts to do stuff, and we know there's something wrong. Most powerful thing I've ever seen in a dissenting opinion in the Supreme Court, the dissenters say that what would be so wrong with accepting McCleskey's argument? What would be so wrong? And the majority's response, if we accept McCleskey's argument under these factors, that's an indictment of our entire criminal justice system, because the next case is going to be a woman who says, hey, there's a 10-to-1 differential if I'm female and between female and male. Or a poor person says there's a 20-to-1 differential that I'm gonna get the death penalty because I'm poor versus somebody who's rich. Mm-hmm. And the majority says if we accept McCleskey's argument, it's going to open up a can of worms. Mm-hmm. And the dissent's response, we think the majority has a fear of too much justice. A fear of too much justice. That's the problem in our society today. That's why we need affirmative action, because we can't stop the discrimination that's going on today because our laws are inadequate. Everybody, and this is what Renee brought up, everybody knows that people have biases. We all have them. I don't care what color you are, you got biases. And the law doesn't deal with that aspect in terms of discrimination. Most bias that occurs is unconscious.
That's right.
We look, there's so many tests, they got the Harvard implicit bias, but there's so many tests out there that say, let's show, we got 2 neighborhoods, the exact same houses, the exact same stores, and then they have people walking in the neighborhood that look black and people walking in the neighborhood that look white. And you know what? Most people say, oh, where the whites are walking, that's a crime-free, nice neighborhood. When you see a black kid running, do you say, oh, he's running from the police because he just committed a crime? Or do you say, oh, he's running to school because he's trying to get an education? Right. Implicit bias. And so we have these, every aspect of the socioeconomic index today, huge racial disparities. Why? Huge racial disparities. Because people have bias and the law doesn't stop it.
Yeah.
Can I say something? I mean, I'm just sitting here listening to Professor Higginbotham. Even after all these years in our education, not even us, those of us here, are immune. I mean, I'll tell you what happened. I'm working as a law clerk at a white majority firm. I'm at law school at Georgetown. We're working for USAA, and I have to interact with the claims adjusters. And one of the adjusters calls the managing partner and says, that guy Christensen, he's fine, he's very good. Where is he from? That was Thomas C. Farrington, deceased. Is he from Norway? He said Christensen.
Right.
Farrington, who was a trailblazer, who was the first white lawyer in the history of Prince George's County to join the NAACP, and who was a person who helped people like Wayne Curry and Tommy Broadwater. He was a trailblazer. I didn't know any of that. He was fantastic sort of social change catalyst. He was having a reception at his home. He says, the guy's name was Luther Tollefson. So I think he maybe had Norwegian roots. Mm-hmm. He says, you'll meet Mr. Christensen. So he had a receiving line at his Woodmore mansion, and I'm in the receiving line for the law firm. He says, Luther, here's Gabriel Christian. He says,
that's a surprise.
and so that was him, but it happened to me. I was working once on a project, and a gentleman who was in charge of the Baltimore Freeport zone spoke to me. It spoke to me at length, and it never occurred to me to ask him, are you white or black? And I just assumed he was white. We're at the Willard Hotel downtown. He calls me and says, "I'm here, Christian. Where are you?" I said, "I'm here too. I'm
right
looking.
here.
I can't see you." He was sitting in front. In fact, what happened when I called back, he picked up the phone, and I'm calling, and I'm hearing him speaking to me. I'm about 10 feet away from him. He was African American.
Yeah.
So I when you were speaking, I was just saying to myself, "You're so right. Those biases of 400 years do not get erased in 20 years or 25 years. By the way, Renee, all the while, from the Bakke case to the present, affirmative action was being battled. It was being battled while I was at law school.
Same, yeah.
A guy called Tom McGuire came out and said that we did not deserve to be there. And the black students at Georgetown University were there only because of...
Well, yeah. I mean, yeah, my first year of law school at UB, a fellow student who was not African-American looked at me and said, "Oh, Renee, you're only here because they needed a quota, affirmative action." I'm like, yeah, sure, because somebody took the LSAT for me. Keep talking.
Yeah.
And that's a very interesting aspect of the divisions in affirmative action, because if you look, 99% of people say no quotas. Quotas are unacceptable. 99% of people say outreach programs where you can encourage people to apply, that's acceptable. So there's tremendous agreement on the spectrum, on the ends of the spectrum. Where the division occurs, where the divisiveness, where the separation on the Supreme Court occurs, is when you have voluntary employment, hiring, or voluntary admissions.
Yes.
And there's a limited number of spots.
Yeah.
Then the question becomes, can you have affirmative action or not? And 4 justices say, of course you can, if you have a good enough reason. And dealing with the great social economic index disparities, correcting that is a good enough reason. 5 justices say, no, it's not. No, it's not.
Professor Renee, Kyla, can I read this? It says, and I wanted to just read it. The Supreme Court banned affirmative action except at military academies. Okay, so I want to just ask the
I'm sorry, because
what was the compelling, if you apply strict scrutiny or whatever, what would have been the legal reasoning if it was enough of a persuasive or compelling public interest to have integrated military academies? Why not the general academic structure of the United States? Please.
You point out a great inconsistency there in the reasoning. There are cases that are going on now where they're challenging the military academies. If you look at previous cases, the military academies, as well as the Fortune 500, filed amicus briefs in these cases saying, hey, we have really good reasons for wanting to have a diverse military, a diverse workforce. And, they talk about the value of the appearance of inclusivity in formulating military leadership and also defending the country, the value of appearing to be inclusive of all the people in our society. And so it's going to be interesting to see the arguments that are going to come out in these cases dealing with the military academies, because I think that's what they're going to say. And they've got strong evidence in support of that. Nelson Mandela, again, going back to South Africa, Nelson Mandela at his treason trial, he said, why, of all the multitudinous groups of people, do you have to have me being tried by a white judge, a white jury, and white lawyers?
Yeah.
Why is that considered justice?
Yeah.
And so the military is going to say, look, we have diverse leadership from top to bottom, And that does a great deal. There's a great deal of benefit for that from the country. And so we'll see what the court has to say on that.
Yeah.
Okay, so I'm going to jump in here because Renee, did you want to say something to that point? But we have a couple questions.
Two things. Okay. I think one, what you're about to say, but before that, maybe offline, I'll share my cynical view about the military and why, but that's separate. But the other thing,
you can share it now because I'll share it. I have a view that.
Okay.
I mean, because I'll share it. I'll share what I think as we were talking, which was I think that there's a the military of the minority, the military of people who when you don't have conscription, which I'm not advocating for conscription, but when you don't have conscription, the military then often people who go to the military are people who are coming from, at least from in my country, it's people who are economically disadvantaged, so it's not a representative military. And so the first that I knew about this exception in the affirmative action case was just now, Gabriel, when you read it, but what I thought it made me think of that. It made me think of ensuring that I guess in some ways ensuring that the military continues to not necessarily be fully representative. Is that
well, kind of, but okay. Yeah, we'll talk offline.
We'll talk more. Okay, but do you have another point?
Well, yeah, the other thing I want to say, I mean, I think it's where you're going. I know that we said we would talk about the voting rights case, which is critical. But what I would love to do is have a second panel so we can devote the entire time on that, which means that we would be asking for another commitment of time for an hour to really talk over it, because we are over 8 o'clock now. And I think that's just my opinion. And I know we're live, but I would love to really unpack this, because part of the series that we have is called Voting, Democracy in Action. And I would love to really, I think we've done a super job of exposing our audience to the nuances of this, the Harvard case and affirmative action. I would love to have this much time on voting rights and kind of what that case is about. But Kyla, that's probably what you were.
Yeah, so actually I was gonna say that we have two questions that I really want to share. I am aware that we're over time. If we're good to go for just like 5 minutes and get these questions, because I think they're really relevant to what we're talking about. And then yes, we'll have to come back because there's a lot more to talk about. We got this question actually before Gabriel Christian used this exact phrase. Shortly after this question came in, which is to do with undermining democracy. And so here's a question that says, if these decisions undermine democracy, how can we depend on democracy to correct them?
That's funny, because I was actually going to pose this question to my fellow panelists in a different way than Daniel Hamlin. That's why should we have hope, right? Because given where we are, but go ahead, Gabriel.
May I? And it's if you want to wax spiritual, you can say it's providential that I got to know Professor Higginbotham across the table from me in that evaluation process that the Judicial Commission for the Appellate Courts represented. And as he made mention earlier in our conversation, it did not always exist. So the commission that he sat on with me and we were all part of was an exercise in inclusivity and democracy, because it sought to represent diverse segments of our state. Folks who are Black, white, women, different parts of the state. And so to answer Mr. Hamlin's question, I believe more democracy, not less. The more we can have diverse views. So let me even take it from the perspective of botany. I'm very close to a gentleman who was one of the leading Black botanists at DuPont Labs. And I learned a lot from him. He went to the University of Illinois, Urbana-Champaign, PhD. And he says in ecosystems that are rich in botanic diversity, those systems are much more resilient to infestation of different kinds and able to sustain themselves and enrich the soil and stuff, so that even in nature, diversity is a benefit. And so if we can vote, and if we can, in that voting, allow for persons to be thrown up who represent different streams of thought in the society, and we can maintain our democratic moorings in having reasoned judgment and discussion, as opposed to exclusion be the preeminent philosophical template for our society, democracy can be enhanced in that fashion. Remember what Professor Higginbotham said. From the Reagan 1980 election, it began to have a very emphatic litmus test focused on excluding persons who had any sensitivity to affirmative action or women's reproductive rights. Mm-hmm. And it's when we begin to have those kinds of what I call dogmatic, ideologically exclusionary templates that are very rigid in that they stifle alternate voices, we see the decline in democratic norms in society. That's my view, at least. The professor may have a different view.
No, I agree. I agree. And I think that you can make changes in our society. Sometimes it takes a while, but you can make changes. And the way we're set up, and look, the Supreme Court is not going to be the most receptive place to civil rights arguments with the current court. Now, it may change at some point, and there are ways to change it, including increasing the numbers on the court. There's nothing wrong with that. It's been done before, and I think maybe that's a way to go. But in the meantime, there are many other ways to focus, because we have a separation of powers. If you get Congress to pass some laws, that's a good way to go, because then you don't have to worry about the court so much. Or if you get the president to implement some enforcement policies, that's another way to go. But even more significantly, we have a concept of federalism, which means, and this is something that has been done over the last couple of decades, that many civil rights protections are done on the state level, not the federal level. So if you get your state legislature to do some stuff, that's something like if you're in a state that doesn't protect abortion rights, what you want to do is you want to get your state legislature to change that. Because with the Supreme Court decision, the Supreme Court says, oh, abortion is not a constitutionally protected right. Now, it's up to the states. And so here in Maryland, we have a lot of protections for abortion rights, but some states do not. So the fight is going to be in the state legislatures to stop them from passing laws that don't respect women's rights.
That's right. And in answer, and Daniel Hamlin, the other thing I think that for me is, we're always looking backwards because we are informed by history. And there have been dark times, but there have been spots of light in our country. And I think that hope with action is critical. And so we know that we can make change. We have seen it. It has not been as fast as we have liked. Some of us have liked. But I hope coupled with action is why we should trust and why we can, because we individually, we collectively, we as Americans with a history of grassroots democracy and action, this is where it is. And so that's part of why we have these programs, because as Gabriel said, this is not a spectator sport. And the time to get off the fence is now. And I'm not talking political, whether you're left or right or independent. This is the time, if you believe in democracy, if you believe in these rights that we take for granted, now is the time to become engaged, to open, to understand how it works and to know how you can make change. And it is, I agree with Professor Higginbotham. Yes, it's at the state level, but we have to drill down. It's at the local county level and school boards and everything that informs policy and how we go forward. It is critical. That's just my plea.
Mhm.
But Kyle, I think you had another question, and then
Yeah, we do. And I think this will probably be, we're going to be at time here, but Professor Higginbotham, you've actually touched on this question already. The writer is wondering, what are your thoughts about term limits for justices or increasing the number of justices? And I know, Professor, you kind of touched on that already. So I'd like to hear about that.
I think it's a good idea. Yeah, I think term limits would be a good idea. I think in increasing the number of justices now, because of what Speaker Mitch McConnell did, it was just absolutely the highest form of hypocrisy when he didn't give President Obama an opportunity to appoint Merrick Garland to the empty seat on the court because he said it was too close to an election, presidential election, and it was 10 months away. And then he turns around and 2 weeks away from the election, allows Amy Coney Barrett to have a hearing. I mean, you need to increase the court 2 spots because of that hypocrisy. But in terms of changes on the court, the justices need to have an ethics provision. I mean, the fact that they don't have an ethics provision applying to them, but all other federal judges do, absolutely ridiculous. So we need to put in some protections now for the court, and term limits, increase the number, and ethics requirements would be a wonderful first step.
yeah. Go ahead, Gabriel. Then
I just think the closing line there, ethics requirements. We, as lawyers, we have ethics requirements. We can't just be, gallivanting with, taking gifts from the person we're litigating against and believe that works. I mean, I'll call his name. I'm reliably informed. It's in the press. It's in the public domain that Clarence Thomas has been seen in the company of and has benefited from the kindness of others who are well endowed financially. And one has to ask oneself, why should it be that working class lawyers like myself, applying all trade, have to comply with the rules of professional conduct? And those who are in charge of our destiny in the highest court in the land have set themselves above the law by not allowing themselves to submit to the same parameters, guidelines, rules of ethical conduct that should be sort of commonplace. I want to also add my endorsement of what Professor Higginbotham said on term limits. Why should it be that the senior executive in the United States, the president, the chief magistrate, as they would sometimes say in old parlance, has term limits, is term limited, 2 terms, and for particular reasons, so that things don't get ossified, that people don't get too comfortable, that people don't take it for granted that you have tenure for life, and so you can get reckless. You see, you have a limited time frame. You're looking at legacy. You know that you don't have all the time in the world. That, I think, would impose on the individual, male or female, a certain degree of discipline. And here, I believe, lies a good solution to include also expansion of the court to maybe 15 or something like that. Again, expanding the bounds of inclusivity. And I'll conclude by saying on this point, and I say this to our Asian brothers and sisters, they, as with Hispanics and other minorities and women, have benefited from the civil rights movement that African Americans led, because African Americans were very, again, I think, majestic in never being ethnocentric, in saying that the rights that they were struggling for were rights only for Black people. So there was this inclusivity ethos in the minds of the Martin Luther King when he talked about Black men and white men, Jew and Gentile. That was his thing. In 1882, I think President Arthur or whatever, there was the Asian Exclusionary Act, where Asians, Chinese were not allowed to come into this country. And it was the onward march of civil rights that African Americans spearheaded that led to the reconsideration of those things. So today you may be a favored minority. Don't mistake that opportunity now and look down on those who, through their sweat, blood, toil, and tears, open the doors for you. And then, of course, it goes for everyone else. Because in a moment, tomorrow, the tables may be turned, and what then? And so it's by embracing that sort of inclusivity, without regard to some racial litmus test of ethnocentrism and racism and racial hierarchy, where we all appeal to the common humanity of our fellow brothers and sisters in ways that some places, like in the Middle East, have not been able to deal with that. And we see what the net result of that is. Unending conflict. Is that what we want? I think those things happen to teach us a lesson about what happens when we don't keep the doors of understanding and of collaborative effort and inclusivity open, when we stifle that innate desire for freedom and liberty and equality of opportunity, we destroy the democratic process. And that is maybe why the military thought it was important, because maybe they may be the last guardians of our democracy. I do not know, but maybe time will tell.
Yeah. And just, I'll quickly answer, and then Kyla, we probably should close. But in answer to the question, I'll only speak to one part of it because I really need to think through the other. I'm not, my gut instinct is I'm not opposed to increasing the number. I'm not. I'm trying to figure out how to counter the argument about, we don't do this, but we know that we have. History has shown us those are people saying that aren't aware of the history where the numbers have been increased. But in terms of the term limits, I am for that, because the reason term limits were not in place was because it was seen as this body of judges who were to be above politics and above influence. But we have demonstrated that is not accurate. And so if that was the reason for it, we need term limits, because just some of the things we've talked about, the influence peddling, the political nature of getting there, all of these things. So yes, I think term limits would be great, and probably increasing the number. But so Kyla, you want to take us home?
Well, I will just say, I mean, first of all, this was absolutely wonderful. And I will say you will definitely be getting an email from me in approximately 4 minutes when we invite you to come back to talk about particularly the voting rights case. But I mean, of course, there is a lot that has happened with the Supreme Court, and we will bring you back. So for people who are listening, please stay tuned, because we will try to find a new date and let you know when you can join us again. And for everybody watching, thank you so much for being with us. Of course, we do this for you, and we appreciate your comments. We appreciate your attention, and you can always reach out to our office if you have questions, if there's things that we didn't get to that you'd like to hear more about. And so I'm going to put up our website up on the screen here. And then, of course, to our panelists. So Gabriel Christian, I have been very fortunate to have known now for a couple of years. He's joined us at other discussions and is just a huge leader in our county, is an inspiration to me. And so I'm just absolutely thrilled that you joined us. I'd also really want to credit you, sir, for the idea for this event tonight. So thank you so much. Professor Higginbotham, it was wonderful for me to meet you, and anybody that Renée loves and that loves Renée, I love as well. And you have proven yourself to be just a wonderful, interesting conversationalist. I'm so glad to have met you. Thank you very much. And of course, Renée, thank you for being with us again tonight. It's always great to have you. And so everybody watching again, please tune in and join us for things in the future, and reach out at any time. Thank you, everybody, and good night.
Thank you. God bless you.